to Module 5 relating to trade secrets. So as a reminder, up until now we've been covering patents, copyrights, and trademarks, which are three aspects of defined protection. We now get into trade secrets. Now, trade secrets, in particular with respect to Segment 5.1, trade secrets are fun because it is really keeping, it's all about keeping secrets secret. And that's a little bit obvious to start out with. If you look at patents or trademarks or copyrights, it's contingent upon there being a disclosure to the government in order for protection to be granted. With trade secrets, it is not the conveyance or the disclosure of information to the government. It's information and disclosure of what actions have been taken to preserve secrets. So at a very high level, that is very much what trade secrets gets at. I'm on page 213 of the textbook, and this relates to the UTSA, Uniform Trade Secrets Act with 1985 amendments. And I've included that for you here to get kind of a sense as to what is actually included. Now, one of the things to keep in mind with respect to the UTSA is that there is not, in short, it is administered by states. So there's not necessarily a federal agency that looks over and ensures that there's compliance with the UTSA. It is a state-by-state application as to whether or not they will adopt rules. You can almost think of this similar to contract law, in that each contract law is by and large governed by state law, but a lot of contracts is governed by the UCC, Uniform Commercial Code, which has been adopted by a majority of the states. It's similar to the UTSA. A majority of the states here have adopted it. With respect to my first question, why is it significant that two states that border each other have adopted it? It ensures consistency as to how it is that the proceedings would occur in each of those states. In other words, if a company, let's say, is in Arizona, which is right next to bordering California or New Mexico, depending on what side you are, if you're a company that's actually actively putting forth goods in each of those states, and you have something that's being kept as a trade secret, then it would allow consistency as far as knowing what the company has to do, whether it's in Arizona or California or Arizona or New Mexico. It would allow the company a consistent plan of action of what they know they must do in order to preserve it as secret. In other words, they know that if they comply with A, B, and C, that in most of the states within the US, that would be compliant with the UTSA and would satisfy their obligations. Now, with respect to the second question, do most companies either pursue trade secret or patent protection? And is there an instance where both can in fact be pursued? And well, especially in the Bay Area, this is actually a question that can come up quite frequently, because companies say, well, is it worth going through the time and expense of getting a patent if I can just keep it a secret? And the rule of law here is usually you would keep things secret that would not be disclosed to the public. If for that which is being disclosed to the public, you probably want a patent on it. So for example, there is in the Bay Area, often you will have 3D printing type companies that will assist with building blocks, building semiconductor type circuitry, and even building little widgets that are essentially like micro widgets. And with all these different types of companies, the end product is provided to the consumer. And so with respect to that end product, those aspects should be protected by patent. But the manner in which things are created before it's actually made public, those creations in fact may be kept secret. Let me give you a definite example. Going back to this concept of 3D type printing, let's assume that you have a secret sauce that is used as a substrate when you're actually building out these 3D type designs. And the substrate, just think of it as a scaffolding. So when you're building a building and you have the scaffolding going up on the side, that's used for a variety of purposes. One, for the construction workers to actually go up and do their work. Secondly, it's used to provide an infrastructure by which you can build upon before everything is kind of in a solid piece. So you can have this infrastructure that goes up that allows you to lay the beams, that allows you to put the ceiling on, that allows you to create the next floor, etc., etc. And that secret sauce is exactly what it is that you're using when you're building these tiny, let's say, little 3D objects. You put your secret sauce substrate in there, which is the scaffolding. You build everything up as you need. And then what do? Well, you can put this in the oven and put it at a very specific temperature. And at that specific temperature, what happens to your secret sauce? It melts away and it just kind of bleeds out of the finished product, such that when you then go ahead and sell that finished product, there is no trace of the secret sauce in it. In other words, a person wouldn't know picking up the product, oh, this was made with secret sauce X, Y, and Z. They wouldn't know. There would be no trace of it. There would be no evidence that it actually was even used. The consumer trying to reverse engineer would say, in order for them to make this, they would need to have some type of a scaffolding system in here. What that scaffolding system is, I don't know. And that is the perfect opportunity for a trade secret. If it is something that is being kept from the consumer and it is associated, obviously the good or services, or the good that's being provided to the consumer is something that could be covered by patent protection because it's something that could be reverse engineered. They can look at it, manipulate it, handle it. But for aspects that lead up to that creation that are not made public, that is what trade secret can really be used for to help protect. So we'll look at three different areas here. One, the statutory basis, two, enforcement, and three, remedies. Let's take a look at a video here that gives a good introduction into trade secrets.
What is trade secret protection and why is it important? Trade secret protection is an alternative to patent or trademark law that allows for intellectual property to remain undisclosed. The subject matter of a trade secret may be virtually any information that is valuable because it is not generally known. Trade secrets have enormous economic value. A study released in March of 2014 estimated that trade secret misappropriation costs the world's top 40 economies 1 to 3% of their gross domestic product each year. Information protected by trade secrets is often valuable because it is unknown and not readily ascertainable. What advantages and disadvantages come with trade secret protection? Trade secret protection carries both advantages and disadvantages. The decision to use trade secret law instead of other kinds of protection depends on the nature of the intellectual property to be protected. Unlike the 20-year time limit for the protection of patents, there is no definite time limit placed on trade secret protection. This indefinite future protection is appealing if the intellectual property to be protected is likely to remain generally unknown well into the future. Although there is no definite expiration of trade secret protection, the protection has its limits. It only prohibits the disclosure or use of the trade secret by one to whom the secret was disclosed in confidence. Unlike patent law, trade secret law does not offer any affirmative protection against the use of the intellectual property if it is independently derived or reverse engineered by a competitor. Consequently, if the intellectual property to be protected is a new method of manufacturing a product, and if that method of manufacture is ascertainable from an examination of the product, then the best form of protection for the intellectual property is most likely patent protection. As the U.S. Supreme Court noted in Bonito Boats versus Thundercraft Boats, state trade secret law has never given the holder of a trade secret protection against reverse engineering by the public or a competitor. The Supreme Court commented that in order to receive protection from reverse engineering, the holder of the intellectual property must seek the protection of federal patent law. In summary, some pros and cons of trade secret protection are: pros. Trade secret law provides indefinite future protection so long as the trade secret stays a secret. Trade secret protection prevents the disclosure or use of the trade secret by one to whom the secret was disclosed in confidence. Cons. If someone comes up with the same idea on their own, the trade secret is no longer protected by law. Trade secret law does not give the holder of a trade secret protection from any reverse engineering. How is trade secret law different from copyright, patent, or trademark law? Unlike copyright and patent law, novelty and tangibility requirements do not apply to trade secret protections. Additionally, patent and trademark law involve an affirmative assertion of an intellectual property right, while trade secret law only actively operates after a misappropriation or threatened misappropriation of the trade secret has occurred. Unlike patents and copyrights that fall under federal law, trade secret protection, until very recently, emanated from state law. What is the legal history of trade secret law in the U.S.? The concept of trade secrets first appeared in the American legal system in the case of Vickery v. Welch in 1837. The Massachusetts Supreme Court first explained trade secret law in modern terms in Peabody v. Norfolk in 1868. Since the Peabody decision, the courts have addressed trade secret issues many times. However, because each state may regulate trade secret law independently, each state has developed its own legal regime to regulate and protect trade secrets. To harmonize and standardize trade secret law in the United States, the Uniform Law Commission published the Uniform Trade Secrets Act, or UTSA, in 1979. The UTSA sought to create a uniform trade secret law regime from state to state. However, the UTSA itself was not binding upon states. For the UTSA to be successful, the states needed to adopt and enact the model UTSA statute with any modifications or customizations each state legislature desired to make. Thus, each of the 48 states that adopted the UTSA may have had a slightly different adaptation. But on May 11, 2016, the Federal Defend Trade Secrets Act, DTSA, was signed into law, thereby creating a federal cause of action for trade secret misappropriation that largely mirrored the law formed under the Uniform Trade Secrets Act, UTSA.
So I'd note, as it was indicated in there, that for the most part, trade secrets relates to or is protected under state law. One of the interesting points that I think it noted was that in 2016 there was in fact federal protection that mirrors the UTSA that allows for a federal cause of action as well. So what are some trade secrets? First off, the formula for Listerine, how it is the recipe for Thomas English muffins, the secret recipe of KFC. By the way, do you know where KFC was originally created? It was not in Kentucky. It was in fact in Salt Lake City. And a cook there wanted to make it sound like it was good Southern food, so we called it Kentucky Fried Chicken. So you can do your research on that. The recipe behind Twinkies, or even the secret formula of Coca-Cola. Or last but not least, the recipe for WD-40. Now what's interesting is that, for example, if we take the example of Coca-Cola, you can definitely reverse engineer the chemical composition of the resulting product. So I can go in and I know that there's so many carbon strains and so much oxygen and hydrogens, and you can then come up and synthesize your own way in order to get to the same result. And that's one of the reasons why you have a lot of knockoffs that quote or look like it's Coca-Cola and taste similar to Coca-Cola, but it is not Coca-Cola. So there's many different roads in order to get to the end goal. And what Coca-Cola has is not only the recipe in order to get to the end road or the end goal, they know the exact road in order to get there. So a lot of these other reverse engineer methods may be using other roads in order to get to that same end goal. And those other roads that they take may create slightly different differences in taste that still ends to the same final product. So, but that's all kept a secret. You know, another one would be Famous Amos or Mrs. Fields cookies and the recipes for those as well. So the statutory basis, patent, copyrights, trademarks focus on granting an exclusive right by the disclosure. And as I indicated, that is a little bit different than trade secrets. Trade secrets does not grant an exclusive right. What it does is it protects against illegal or wrongful access to information that has purposely not been disclosed. So it's the non-disclosure of information that's being protected here, rather than in contrast to patents, trademarks, and copyrights, that is specifically governed based off of disclosure to the government. When these slides were created, I indicated that there's no federal trade secret statute, but again, in 2016, there was a federal cause of action that allows for a trade secret basis that is based off of the UTSA. More than 40 states, I think 48 currently states, have adopted the UTSA as well. So as far as strategy for using trade secret type protection, a company may choose between pursuing patent protection, which is a disclosure to the world in exchange for some type of limited monopoly rights in return, or trade secret protection, in which you keep it a secret and have protection as long as it is kept a secret. And as we've discussed, you can actually pursue both of these based off of different elements of what it is that you are seeking protection of. That which the consumer can see, manipulate, reverse engineer, you can protect that by patents, and that which they don't know how it is that you get to the end goal, or that which the consumer doesn't see, you might want to protect by trade secret. The UTSA defines a trade secret as essentially three different things, or three different steps, I should say. The first step is that it is information, including formula, pattern, compilation, program, device, method, technique, or process. So in other words, is information that leads us to the second step, which is that derives independent economic value. So, and that independent economic value, actual or potential, is not generally known to or readily ascertainable through appropriate means by other persons who might obtain economic value from its disclosure or use. So it's information that provides economic value that leads us to the third step, and that is the subject of effort that are reasonable under the circumstances to maintain its secrecy. So the first one is that it's information. Second step is that it is providing economic value. And then the third one, efforts are taken to maintain its secrecy.